Building successful employee relationships, a cornerstone to fraud prevention and risk management, was a live webinar that was originally produced on Thursday, February 18th, 2016. The presenters for this presentation were David Hammerberg and Sam Bowercraft with McKonly Asbury, and special guest Eric Stark with Cipriani and Werner Law Firm. Enjoy this webinar recap and visit us online at www.macpas.com for more information about our future events and presentations.
Good afternoon, everyone. My name is Sam Bowercraft. As Tyler mentioned, I'm a senior manager at McKonly Asbury, and I'm here today with Dave Hammerberg and Eric Stark. We're looking forward to speaking to you today about building successful employee relationships and mitigating risk around human resources and preventing fraud. Dave here has 15 years of experience in the accounting world and with fraud investigations and fraud prevention. And Eric has 10 plus years with employment law, or human resources law, as I referred to it earlier. And I'm going to let them tell you a little bit about themselves. Eric?
All right. Good afternoon, folks. Again, my name is Eric Stark. I'm a partner with Cipriani and Werner. I'm also a real person, believe it or not. Many people don't think of attorneys as real people, but I am born and raised in central Pennsylvania. I grew up in Elizabethtown, Lancaster County, went to Elizabethtown College and then Widener Law School. As Sam mentioned, I've been doing employment law for the 10 years of my active practice, and one of the things that gives me great pride, and one of the reasons I'm doing this webinar this afternoon, is that I like to try to keep people and keep my clients out of trouble. So a lot of what you're going to hear from me this afternoon is going to be best practices for how to avoid the courtroom, so to speak.
Excellent. Thank you, Eric. And if anyone asks me later, I will confirm that you are a real person.
Thank you. I appreciate that as well.
No problem. Dave?
Good afternoon. My name is Dave Hammerberg, principal here at McKonly Asbury for 15 years. Been doing risk assessments, fraud investigations, IT consulting, cybersecurity, etc. I, too, am a real person, regardless of what Sam says. Enjoy doing things outside when I'm not here with Sam and Eric, and doing forensic work, helping clients, try to prevent fraud, and if we don't prevent it, help investigate it, detect it. With that, I've worked with Sam in many engagements. He has 11 years of experience in the consulting field, and prior to coming to McKonly Asbury, he has 7 years of experience with IT consulting.
That's right. And that doesn't count the amount of time I spent helping my mother with her computer. So, excellent. Well, we're going to jump right into the objectives, and we're all set. So today our focus is on increasing the understanding of the risks associated with the hiring and retention of employees. We're going to focus and discuss employment law and how that also impacts fraud and operations, and of course fraud prevention, which is what we'd all prefer to do. We encourage our clients to do what they can to stay out of trouble, as Eric mentioned earlier. We want to gain a better understanding of some of the new legal requirements as well. I asked Eric earlier if we could cover this in an hour, and Eric said,
absolutely. Lawyers never run out of things to talk about or have trouble coming up with new issues to discuss.
Yes.
So.
Yeah, we have plenty of content to go over today, so we'll address what we can. And if you have any questions as we go along, please feel free to submit them as we're talking about these different areas, and we'll address them as we can. And we'll get started. So, common organizational structure. The employee-employer relationship is a foundation for a successful business. Obviously, it's important that employees make up all organizations and they make things happen. All the processes and operations and everything that makes a business successful really happens because the people are making those things happen. They're the cornerstone of any organization. So as far as the hiring process, obviously we want to get good employees in place. Eric, what are the top 3 components that you think are related to the hiring process? What areas should we focus on?
Well, I think traditionally anyway, there are 3 big things that we talk to employers about in the hiring process. One is what's involved with the interview. What types of questions can you ask versus what you can't ask from a legal perspective? Secondly, we talk about the background checks process in terms of what information you can learn and how you can use it about a prospective employee. And third, we talk to companies a lot about post-offer pre-employment physical exams, because those are, again, an important way for a company to gather information about a prospective employee in terms of being able to determine whether or not the person can actually do the job that they're being asked to do. I would say, in a more contemporary sense, 3A would be the impact and role of social media in the hiring process, and we'll touch on that a little bit this afternoon as well.
Very good. Dave, what about you? When you worry about fraud prevention, what are the areas of focus for a hiring process?
During the hiring process, employers don't oftentimes think of fraud and fraud prevention, and it's such an interesting topic. When Eric and I got together, employment law and fraud, how does it fit together? We go on and on about the fraud triangle, and a lot of people are, maybe tired of hearing the fraud triangle. But there's three legs of the fraud triangle. We really hit the opportunity side, and we try to reduce that opportunity side. We put controls in place, et cetera. And then we always say pressure. We really can't do a whole lot with pressure. Most of the pressures are external, gambling, addiction, whatnot. But rationalization is one area where we can work on in the hiring process. Rationalization, how do people justify their feelings or their decisions? And we have one really chance to look at an employee. Say we're hiring Sam. What is gray and white to him? What is black and white? Sorry. How does he make decisions? So I want to focus on that. And I think a lot of times, from a employer standpoint, in regards to fraud, we're almost scared to what questions we can ask. What is that boundary line we can go to? But this, again, is one area where we can dive into and kind of understand that candidate before they become an employee. Because once they become an employee, I think it becomes a lot tougher after that to do anything about that rationalization side of the triangle.
Right, and I think that there really are, in the employment law context, few blacks and few whites, quote unquote. There is a lot of shades of gray in this context. We're going to touch on some of the very basic principles in terms of how to avoid legal problems and pitfalls, but a lot of it really will come down to judgment calls and questions about what can and can't be asked, and how information you as an employer receive about someone or learn about someone through the hiring process, how that can be used is, as we talked about, really a shade of gray, so to speak.
And one of the things you mentioned, Eric, with regard to post-offer pre-employment physical exams and background checks, and I think we were going to talk about this a little bit later as well, possibly, but I'll bring it up now, was how appropriate those are about what kind of background checks you can and can't do and when you can and cannot do them, and what sort of you can do them, but you have to sort of check the box on certain things. Did you want to talk about that a little bit?
Sure, I can touch on that. There's a couple of principles that I think you need to keep in mind very broadly. Number one is that there is no state or federal background check law or act. There are other areas of the law that apply themselves to the types of information that employers can get through the background check process. In Pennsylvania, in particular, we look to an element of the criminal code, in fact. The criminal code tells us one example where the only types of criminal backgrounds that can be considered by an employer are misdemeanors and felonies, to the extent that those affect the prospective employee's ability to do the job. In other words, an employer by law, can't take into consideration summary offenses in the context of the employment background check process. One of the other big principles to keep in mind is that the discrimination laws, both state and federal, are applicable throughout the hiring process. One of the things that comes up often in the context of a job that will be physically demanding, or at least have some measure of physical requirements, is the Americans with Disabilities Act. You'll hear me refer to that as the ADA throughout the presentation, but you'll know what that means. And that law does still apply during the hiring process, and it's important for an employer to keep that in mind. The third big sort of broad area of law that is applicable during the hiring process is federal law, the Fair Credit Reporting Act. FCRA would be the acronym there that we'll use from time to time. And that act very broadly protects prospective employees as to how employers can use information that's found through a credit check. There are specific requirements in the act regarding authorization on the part of the employee to allow an employer to get information, and there are specific requirements that allow employees to cure information that may be perceived as a negative that's found by an employer through the credit check process. So those are kind of three big areas. And then you have social media just sort of thrown in. Nobody really knows exactly what the law is in that regard. We're stuck applying many of these other broad principles to the ever-changing world of social media. So we're kind of making that one up as we go along, so to speak.
Very good. Dave.
Eric, you mentioned in the beginning there about when you're doing background checks, how relevant that is to the position that the individual is going for. And from a fraud standpoint, I'm looking at the integrity of the employee. So, if the individual's, say, driving truck, that's the position or whatnot, and they have the background check brings up that, petty theft or something like that. And maybe it's not directly related, maybe that's not a good example. But from a fraud standpoint, that's kind of measuring the integrity of the employee. And sometimes that's enough for, even with risk assessments, for employers to say, hey, this person did this in their personal life. We want to do some kind of risk assessment because if they did it in their personal life, it could happen in the business. So if I'm interviewing someone and, it's unrelated, can I document and say, hey, from a fraud standpoint, I'm worried about the integrity of this employee, even though it's an unrelated circumstance. I mean, is that enough to say, hey, we're not going to hire Sam because of this?
I believe that in a very broad sense, the short answer to your question is yes, that is enough. As an attorney that represents employers exclusively, what I would say is that I would make a very strong argument in that type of a scenario that any type of fraud offense in an individual's background is sufficient to deny employment because of the fact that integrity runs throughout the job for each of these individuals. We see that in the case law. The case law around this area tells us basically that an employer is able to take action for dishonesty, whether that's terminating an employee, disciplining an employee, things of that nature. The other highlight I wanted to mention in this context is that in the event that you do use that fraud background check positive result, criminal conviction, however you want to word it, to deny employment or to discipline someone or terminate someone even after they've been hired, it's still very important to have that not only documented as to how you found the information, exactly what information you found, but connecting that specifically to the job that the person is seeking or the job that the person has. How do we do that? Well, in the employment law world, that comes often, and the best practice, through having a written job description. One of the essential functions of your job descriptions really should be honesty and integrity, because then you can connect a fraud, offense, criminal background to the essential functions of the job that the person is either doing or is an applicant to do.
How specific would you get in response? So, say, we were hiring Sam, and I use Sam because, anyway.
Can we use someone
we won't
else?
Get into that.
I'm just. Can we use another Sam, maybe?
So the other Sam that we're not hiring, what's my response to him? Obviously, we don't want him to think we're discriminating against him for one reason or another, but there is a specific reason why we're not hiring him. What, as an employer, should I do or not do after I decide, hey, I'm not going to be hiring that other Sam because I feel like the integrity of that individual is not there?
I think a best practice would be to clearly inform the prospective employee of the reasons that they will not be hired. And I would do that absolutely, positively in writing. I don't believe that you need to specify each and every element of your thought process as an employer as to why an offense was not acceptable to you for whatever reason. But I do think it's important to document and connect in writing the reason why the employee was not hired to what your job descriptions are or what your job requirements are, so that there's a clear connection between results of the background and the job, and therefore why the person was either not hired or was disciplined or terminated.
I think on the face that makes a lot of sense. I would argue the other side, where some might say that by documenting that sort of connection, you may create or increase your exposure to litigation because there's clearly documented evidence about, well, there was an interview, there was this documentation, there's a rejection letter that describes the reason for not being hired. Does that increase exposure, or and because I think in a lot of cases some employers may just fail to follow up with people and leave them hanging in the void rather than document that train of thought?
I think, again, that your point is well taken, that generally less is more, but in terms of documenting the connection between background check result with reason for the rejection and then connecting all of that to what the job required, I think that helps you in a litigation context, because let's face it, none of us can control whether or not a prospective employee or someone that even we've gone so far as to actually hire and then terminate will sue you. But what we can control, and what the documentation then allows us to control and craft, is our response to that type of an action. And one of the first things that will come up in that context is what was your documentation at the time that you rejected the applicant. If you're asked by either your attorney, the other attorney, or a state or federal agency that's called upon to investigate this cause of action, their first question is going to be, well, what did you tell the employee? And then if nothing is documented, you're left with, well, I recall that we brought him into my office, or I recall that we called him on the phone and this is what we told him. And then you're in essentially a he said, she said situation, which never really plays well from an employment defense standpoint.
So articulating those things becomes very important just to general operating.
Yes, and I do think that there's a distinction between the public message of what you specifically tell the prospective employee. I think it should be a carefully worded letter, and what your internal documentation reflects. I think your internal documentation is where maybe you add to some of that rationale, you put some meat on the bones, so to speak, of your analysis and your thought process. But I do still think that documenting and connecting reason why to a prospective employee is a best practice.
Okay, very good. Well, we talked a bit about the hiring practice and sort of best things to address there as we set context here. Eric, what do you think the top 3 components of managing current employees are and maintaining the relationship there?
Well, I think that there are a couple of key things. Number one, I think your employees, in terms of management, must have clear standards. How do we get those clear standards? 3 things in my mind. Number one, you have an existing company handbook that sets forth the standards of behavior, standards of conduct, consequences for violating policy, consequences for dishonesty, etc. Number 2, that you apply that policy consistently. And the consistent application of your existing policy is what will guide any third-party reviewer into what you've done with a particular employee, whether that's me as your legal counsel, whether it's the employee's attorney, should they get one, whether it's an agency that's called upon to investigate what is believed to be inappropriate conduct on the part of the employer, or anyone else. The third thing, then, is really where lawyers and real estate agents are similar. In real estate, agents will tell you the 3 most important things are location, location, location. Well, it's not quite location, location, location for lawyers. It's something similar, though. Documentation, documentation, documentation. And again, if it wasn't documented, it didn't happen. And I think that those 3 key principles are always important.
Going back to the handbook you mentioned, and this just a question: what there's a lot more. Or it seems like there's a lot more things you can do, background checks, etc., when an employee starts. Is there stuff that we can put in the handbook that could help us throughout the employment time to do those checks and background checks? And the other Sam, if we decide, hey, we want to look back at him, do we have to look at him, or do we have to look at everyone? Is there what can we do there?
Sure. I think that there are a few things. First of all, when we talk about applying your existing policies, they must, by law, be applied across the board equally to all job categories and all job classes. You can make distinctions within categories of employees, but they must all be equally treated within those categories. In terms of the question about how do we follow up and make sure, I think that one element of your handbook could very well create an obligation on the part of the employee to report things that happen to them that may affect their ability to do the job. The classic example is a bank teller who is naturally handling other people's money all the time on a regular basis, and that bank teller is convicted for some type of theft offense, even if it's a low-level, quote-unquote, retail theft offense. Well, that bank teller is now in a position of trust with someone else's money, and with a criminal conviction like that on his or her background, that's a problem for an employer in terms of future litigation if they do nothing, quite frankly. So requiring an employee to report to you as an employer offenses or criminal conduct or things of that nature in their lives is one element of your handbook policy that you could have.
So kind of switching around, instead of doing the background checks yourself, having them report to you.
Yes.
I guess the question there is, if you have a substandard integrity individual are they going to be reporting back to you? But I guess from a liability standpoint, you have it in the policy. You can go back and say, hey, they were supposed to report, they didn't, and I mean, I guess that's where you're kind of getting at right there.
Yes, that's what I'm getting at. I think that I'm not sure from an employment law perspective how comfortable that I would be with doing a similar series of background checks on employees every year or every other year or every 6 months, because let's also remember that what we don't know in an employment law context may actually help us. And what I mean by that is that the more information that we know about an employee or a prospective employee, the more potential responsibility we have as an employer to maintain compliance with federal law. The one example that I always think of in this context is the social media one, because it's so common. And I don't think it applies just in the pre-employment context, but as Dave's suggesting, in the event that you have a periodic background check or background screen process, let's say, for instance, you just once a year Facebook stalk your employees, to use the vernacular there, and you Facebook stalk Susan, who's your
or Sam.
Or Sam, yes. Probably Sam's Facebook page might be a little more interesting. So what if you're doing that and you discover on their public Facebook page that the individual indicates a chronic medical condition on there? You as the employer were never previously aware of that. It never came up in the context of their employment. They were never in a position to come to you as an employer and say, hey, I have these medical restrictions. I can no longer do the driving component of my job, or another element of their job, a lifting component, a typing component for people that might have certain conditions. And you discover that, lo and behold, someone posts on their website or on their Facebook profile that they're scheduled for a back appointment, and they're concerned that they've had back pain for the course of the last 5 years, and they have a herniated disc in their back, and they're not sure what they're going to do about it, because people post those kinds of things all the time, even in a public forum like Facebook. You now, as an employer, are on notice of what I would say is clearly a disability, as the Americans with Disabilities Act defines that term, and you now have potentially an obligation to determine whether or not you can accommodate the person in the job. And so you might not want to know all that there is to know in someone's background, because it may create additional legal obligations on the part of the employer in order to comply with federal law, really.
Interesting.
I would think it would get rather costly for background checks as well if we did, yearly, annual background checks like we did when we hire someone. Probably another deterrent, I would imagine.
Yes, I think so. And I think that, again, the cost is really, I think, the tip of the iceberg, so to speak, because there's a lot of things underneath that tip of the iceberg that we may not want to necessarily get into or even know about in the employment law context.
When you're in the hiring phase, I guess you can pretty much move on. Move to the next person. Once they're hired, you sort of have to deal with what you have, and it sounds like what you're saying is sometimes you just better off not knowing what you have.
Yes, I agree.
And moving on, and maybe working on the controlling the individual's opportunities, as well as rather than trying to figure out if that person's going to make the right decisions.
Yes, I agree with that.
So when we talk about, you mentioned job descriptions, and this is associated with a question that just came up. When we talk about job descriptions versus employee handbook or code of conduct, you talked about mentioning honesty and integrity in the job description. Presume it would also be mentioned in the code of conduct as well. Would you refer to the code of conduct in a job description? Employee will follow the code of conduct as well. Are you including that by reference? Do you need to state it in both places? Does that create a level of effort to maintain consistency across that?
I think it does. I would want, though, both places to be consistent with each other, and I would furthermore want both documents, the job description and your actual code of conduct, to be freestanding documents that will basically say what you need them to say independent of one another.
Okay.
And I say that because in the job description context in particular, again, this is sort of fancy legalese, but I think you get the point that the essential functions of the job are what any, again, third-party reviewer is going to look at. And I think certainly integrity and honesty are always essential functions, or should always be essential functions of the job, because quite frankly, in the event that you have a problem with an employee from a disciplinary standpoint, you can always come back to those two foundational points. They're kind of catch-alls as it relates to the employer-employee relationship, I think.
Yeah, and as we talk about fraud prevention and fraud investigation here at McKonly, we are very cautious about making presumptions about things and making sure that we're not presuming knowledge in documents like job descriptions or code of conduct. We don't presume that you'll act with, we do presume you'll act with honesty and integrity, but we also need to articulate it as well. I think that speaks very highly to the slide that's been up for a little bit, where we talk about companies' employment and management processes and how they set expectations for relationships, where we talk about environment and culture. When you had presented this slide, I understood what those words meant and do mean, and we talk about acceptable and unacceptable behavior. But I think you had a very interesting definition and difference between environment versus culture, and I think if you could expand on that a little bit.
Sure.
Good.
I look at environment and culture as being distinct from one another in that culture is really the goal that an employer is striving for as it relates to how their business runs and how they interact with their employees. I think environment is more the functional reality of that. So if you look at culture as the goal and an environment as the reality, you naturally want your environment to match up as closely as possible with your culture. Well, one of the ways in which that happens, and one of the most important ways in which that happens, is to establish and then implement an effective policy standard for your employees that clearly outlines what is acceptable and unacceptable behavior from the standpoint of measuring success or at least adequate performance on the job. So if you can marry culture and environment and then support that with written policy, I think that, again, we're talking about best practices, and I think that really is just that.
So which is worse, and this is for both of you, to have a policy and not enforce it, or to have no policy?
In my opinion, I would say to have a policy and not enforce it would be your biggest problem. Just because it shows that you knew you should be doing it and you didn't, from a security standpoint as well as from a fraud standpoint. So, attorney may have a different viewpoint. We'll see.
And you can't hear Eric, but his head is shaking. Yes.
I absolutely agree with that. I think it is always worse to have a policy and not enforce it or not utilize it than to have no policy at all, because there's a couple of points within there. Number one, I think that your written policy should be attainable. If you're placing an obligation on your employees or on yourself as an employer, it should be something that you can actually do in reality. If it's not, you've now created Exhibit A in the legal action against you when you have not complied with your own policy. So in many instances, I think that having a policy that hits the key points and gives an employer the discretion to take action is kind of the happy medium. You've got something in writing that sets forth the standards, but then you as an employer have the ability within the policy to use your own discretion. So you're not binding yourself to following A through Z in terms of a procedure for dealing with a situation, but rather you're binding yourself to general principles and then applying those general principles to the specific circumstances of your case really is where that employer discretion comes in.
Very good.
Exactly what I said. I was just joking. Good.
So our next slide just lists off obviously some risks we like to avoid. Obviously the wrong employee in the wrong position, bad employees, bad fit for the role, employees without honesty or integrity, bottom line impact due to the cost of replacement. Just a quick statistic for the group. It costs usually about 40% of the annual employee's salary and benefits to replace an employee. So if their salary and benefits is $100,000 a year, it's going to cost you $40,000 just to replace that individual. So hiring right the first time seems like a very cost-effective approach, and guys are shaking their heads yes. So,
and that 40% is just rehiring someone else. If that employee commits fraud, et cetera, or costs the employer in different ways, that's above that.
Right. Whether
that
it's
cost, so.
Whether it's fraudulent behavior or operational challenges because they didn't do their job well or correctly. Absolutely.
So I think the thing we're really hitting on is, you really have to make good decisions when you hire someone. I mean, that's really when you have to make the decisions. We can affect it afterwards a bit, but it's really in the beginning there is when we really have a chance to at least affect from a fraud standpoint.
Right, and I think the other potential cost here that we're talking about, leave it to the lawyer to bring up litigation lawsuits, I suppose. But that is honestly a big cost that I would imagine is not necessarily calculated into the 40% figure. Just so that you understand, and this is another statistic, but the bare minimum case that someone could just file and allege that they were discriminated against or that the employer acted incorrectly in terminating them or disciplining them or used inappropriate standards, you're looking at anywhere between $25,000 and $50,000 of actual output between hiring a legal defense team, the costs associated with responding to those allegations, to even if the allegations ultimately don't prove to have merit, you're going to look at some point to settle that case. And those are, again, significant sort of under the tip of the iceberg types of costs that an employer needs to at least be aware of.
So whether we're talking about fraud or hiring practices, really an ounce of prevention is worth a pound of cure.
Yes, absolutely.
Excellent. Well, let's talk about some prevention items. Obviously, there are lots of right things to do. Drafting and reviewing job descriptions, conducting a post-offer pre-employment physical examination. We talked a little bit about that earlier. And consulting experts when necessary. Let's do a quick poll to while we talk about this next topic. If everyone just answer this question: does your company have or maintain a set of job descriptions? But I think we talked about this already some. Job descriptions mitigate risk. They set expectations for possible disciplinary action later. Defense of workers' compensation claim. We talked about that earlier, Eric, in detail. Reviewing them annually to make sure they're up to date. I think also important, whether it's the human resource side or fraud prevention, to make sure that people are still properly allocated to their jobs and have clear expectations. When we talk about the post-offer pre-employment examination, what is the real important risk to mitigate there? Because it's after you made an offer, but it's before they're really hired. Is that correct?
Yes, that's correct. That's exactly when that exam takes place. The risk that you're looking to mitigate there really is one that deals with the prospective employee's ability to do the job that's being offered or discussed from a physical standpoint. Medical doctors will assess whether or not someone can lift up to 50 pounds through an exam process. That may be important for a FedEx driver, for instance. And one of the sort of hidden purposes of that, which is really important, is to protect yourselves from a potential workers' compensation claim. If your company has an established practice where they use post-offer pre-employment physical exams, your workers' compensation costs on the back end are likely to be significantly reduced because you're going to hire people that can do the job from a physical standpoint at the outset of that. And in the workers' compensation world, employers must take their employees as they find them. And what that means is that employers can be liable for aggravations or exacerbations of an existing or underlying medical condition. But the more information that we have in terms of specifically whether the employee can perform the essential functions of those jobs or that job that they're applying for, the better off we're going to be in terms of curbing or mitigating our workers' comp costs.
Very good. The responses are in for our survey question. Looks like a pretty large portion of the group has job descriptions, 71%, 22% kind of, which is kind of surprising. And of course, some people just don't know, and that's I think that's fairly representative of my experience as well. And depending on the organization and how formal it is and what kind of regulations they experience, they may or may not have job descriptions just because that's part of their environment and not necessarily the culture, right?
Right, and it is. I mean, as much as I'm kind of sitting here and telling you what the best practices are, lawyers are also understanding and reasonable when it comes to helping their clients actually achieve those best practices. So we understand that it's not the easiest thing to always be aware of what your job descriptions say and be on top of them and review them annually. But what I would encourage you to do is to at least familiarize yourselves with your job descriptions, because while they may not immediately provide you with a benefit in the context of your day-to-day duties or functions, but they will pay dividends 10 times over in the context of what we're talking about today, the hiring process, the process where we must take disciplinary action against an employee or things of that nature, because really they are the first thing that employment law attorneys that are on the other side will look to in order to determine whether or not their client was treated fairly or not.
From a fraud standpoint, that's one of the first things I look at when I go in for a fraud investigation. I want to know what that employee's job description was, and of course controls that were in place, et cetera. But it's an important thing to have, and it's amazing how many employers, small to large, a lot of them will have them, but they haven't been updated in 10 years, and the position is totally different than what the job description says. So it makes it tough relying on that documentation.
Yes, and I think that relying on that documentation really summarizes it, because that is what you as an employer are going to be doing, and what we as your counsel will be doing as well in assessing not only your risk, but what your next step should be. And understand this also, that when a cause of action has been filed, whether that's at the state or local or federal court level, it's too late at that point. You can't go backwards and create job descriptions that were applicable to something that was done a year and a half ago. So unfortunately, once that action has been filed, the bell has been rung and it can't be unrung, so to speak. So it's important to have them in place truly as a protective matter.
Well, and it sounds like to me, and this is my experience with the fraud side with you as well, Dave, which is in the absence of documentation, the employer is at a disadvantage because after the cause of action, you can't go back and create the documentation. On the fraud side, we've seen this before where there isn't good job descriptions, there aren't good processes or controls in place, and there's no evidence to that fact. And in the absence of that evidence, it makes it much more difficult to prosecute for fraudulent action and behavior, and to then recoup some of those losses.
And I think we harped on in the last webinar was, the prevention is a whole lot cheaper. Making job descriptions, putting controls in place, preventing fraud or preventing a lawsuit is going to be 10 times cheaper on the front end. So not to harp on that again, but that's,
Well, I think it's an important thing to note. And I think when we talk about cost as well, we talk about cost, it's easy to quantify that. But whether it's in cases of fraud, usually frauds aren't a significant dollar amount. They can be, but they're usually smaller in general. But I think that the impact of the organization can be very significant.
The impact to the organization, not only from an employee standpoint, a cultural standpoint, but just from an outside someone looking in. How does that impact that, the integrity of that company?
Yeah.
Can you trust that company? Do you want to work with that company? We've had some local companies that have had some security breaches, et cetera, and it's tough for them to get clients. So we want to make sure that our, the organizations, our clients, look to the outside world as good as possible. And if you have a lawsuit or a fraud occur, it can only hurt you.
Yeah, and to me, avoiding that organizational cost and organizational stress is very important. We're just coming up on time here in just a few minutes. If you have any questions, please post them straight away, and we'll try and address them as quickly as possible. And we'll just move on to our next slide here, Management Practices 101. So obviously we talked a lot about drafting and updating the company handbook and making sure that's disseminated, applying existing policy consistently. We've talked about that, and ensuring adequate documentation. Eric mentioned this earlier. If it's not documented, it didn't happen. That's definitely an audit standard as well. In the absence of documentation, we presume that it didn't occur. Very, very important to not only setting clear expectation, but also being able to stand up a defense. Right, Eric?
Yes, absolutely. And again, I think that one of the things that employers do from time to time, which I would encourage them to avoid if they can, is to give the same message to the employee that you gave internally. In the event that you elect to terminate an employee, for instance, I think that your documentation internally should fully reflect your thought processes, your analysis as to why the conduct rose to the level of termination, and then also connecting that conduct to your written policy. And I think that that's what internally you should have. But I don't think that the terminated employee should get a clear window into all of your thought processes, your discussion points, all of your analysis. I think that the employee should receive a carefully winnowed, so to speak, letter that clearly connects the conduct with policy and explains in plain English why the conduct rose to the level of termination. But I don't think that they just get everything and a lengthy explanation for exactly how your decision was reached. I think that's where I would encourage employers that there is a difference and that less is more in the context of a written letter to an employee regarding a disciplinary issue or action, so to speak.
Very good. Well, we're just running up on time. We're going to do one quick survey here at the end. Which of these do you think is the most important to improving employee management in your organization? We have a couple different answers here. Feel free to pick the one you think would most benefit your organization. As we come up on the end of our presentation, Eric, I think you said earlier that we would get through everything in 1 hour, but you're right. Lawyers can talk. So there are definitely some additional topics, and there's plenty to go over in this subject area.
And it's typically quite interesting because one of the things that we didn't get to today that may be a subject for future discussions is hypothetical scenarios because with combined here at the table, we've got more than 30 years of experience doing this kind of thing very broadly. And we all have, quote-unquote, war stories to share. And so while we didn't hit on those today, I think that they do provide good learning tools. And I think that we have plenty of those that are entertaining in our back pocket and also informative and instructional. So.
Yeah, I think that's a great comment because, when you're hiring an employee, it's nice to give them a hypothetical situation and figure out what's going to do, but it's sometimes hard to come up with those situations. And we sort of in this group here have some really real situations that you could use in a hiring process. So that could be a whole nother topic.
Sure.
Yeah, absolutely. And through our discussion with this, I think one of the things that's been highlighted, from our work on the fraud side and from your work on the legal side, Eric, is that a lot of the risk mitigation tools in this area are really nuts and bolts things. They're not snazzy. They're not really fancy or anything. It's you just got to sit down and do the work to make sure that you're doing the right things in these different areas. And that being said, we'll go to our survey results here. Looks like nobody wants to do more job descriptions or employee handbook work, but it might help some people. Improve hiring process and management process might help some organizations. And I had added this last one, internal training for hiring and managing employees. I think that's a really important aspect. I think it's easy to put these documents in place, whether it's job descriptions, an employee handbook, and expect that individuals will read it and understand it. But I think as we talked about earlier about culture, which is what we're going for versus environment, I think the gap between culture and environment frequently is training. It's not about documentation or communication, but it's really about training and making sure that the message is not only told to people but also repeated in a consistent manner so that they're doing what's expected and what's desired, and then people can ask questions about what the gaps are about their expectation. Would you guys agree with that?
Yes, and I would suggest that employees know who they work for. And that seems like a very obvious point, but it's an important one, I think, because an employee is probably your best source of information as to the environment that they work in. The management level folks or the human resources professionals or your attorney or your accountant may very well be able to tell you what the culture that you strive for is. But your employees are the ones that are going to be able to tell you, not only through words but through their behavior, as to exactly who you are as an employer as it relates to the environment that you create.
Dave, any last thoughts?
I agree completely with that last statement. I mean, when we talk about risk assessments a lot of times, we're talking about, hey, we're not talking about with management of what they think is happening. We're talking to the employees, ground level, and understanding what is happening. So I think that's probably another way of saying what you just said.
Very good. Well, on that note, I think we'll wrap things up here today. Thank you very much for joining us. We hope that this has helped you to better understand risks associated with the hiring and retention of employees and managing them, the benefits of really taking care of these nuts and bolts actions. We'll leave you with this question. What small change do you think you can make in your environment to reduce your HR risk going forward? We look forward to any feedback that you have regarding this webinar. We hope you enjoyed it, and we'll see you next time. Thank you.
Thank you once again for joining us for this presentation produced by McKonly Asbury. We hope you join us for our upcoming events. You can stay up to date with news and learn more about our upcoming events by visiting us at www.macpas.com. Thanks again and have a great day.